case is People versus Poole. Sorry, I didn't mean to give you a second. This is a 20-minute grant, which means counsel for each side has 20 minutes and Amicus has 8 minutes. Mr. Boffman, we would have given Amicus on your side 8 minutes as well. If you need additional time to respond to anything from Amicus, we will make sure you have that time. And if you are ready to proceed, counsel, you may.
Good afternoon, Chief Justice and Justices. May it please the Court, Maya Menlo appearing with Adrian Young on behalf of John Antonio Poole. I'll try to reserve 4 minutes for rebuttal. This Court should hold that Mr. Poole's mandatory life without the possibility of parole sentence is unconstitutional under Article 1, Section 16 of the Michigan Constitution. Mr. Poole's motion is based on the law of Miller and Montgomery, because before Miller, the law in the state of Michigan was that every person, regardless of age, who was convicted of first-degree murder would be sentenced to mandatory life without parole. But after Miller, we know that's not true. 18-year and under defendants cannot be sentenced to life without parole mandatorily. That is unconstitutional. That rule was made retroactive in Montgomery, and now based on that retroactive change in law, Mr. Poole filed a motion for relief from judgment and asked this Court to hold that his mandatory life without parole sentence is cruel, unusual, or both under the Michigan Constitution. This request is also based on a recent evolution in the science of the adolescent brain that tells us that 17-year-olds and 18-year-olds are indistinguishable for the purposes of sentencing. Just like a 17-year-old, 18-year-old Mr. Poole demonstrated transient immaturity, vulnerability to outside influences, and a heightened capacity for rehabilitation. Even though his youth mitigates his culpability just like a 17-year-old's youth mitigates their culpability, the trial court could not consider that because the statute mandates a life without parole sentence. This Court should find that Mr. Poole's mandatory life without parole sentence is unconstitutional and therefore invalid, and remand for resentencing. I welcome this Court's questions at any time.
Counsel, the thing I struggle with this, what's the cutoff?
The science supports a cutoff at age 25. The National Academy of Sciences in 2019 released a consensus report that talks about the science supporting an extension of protections offered to those under 18 into the mid-20s. Our amicus brief by the neuroscientists, psychologists, and criminal justice scholars discusses this in great detail. There is a scientific consensus that youth is mitigating beyond 18, and that 18 is an arbitrary and really meaningless cutoff in terms of scientific development.
For 25, I mean, you realize that, like my parents got married at 21 and started a family. I mean, it's hard. This is a tough one, right? Like, you understand that there has to be some kind of a way to end this.
I understand, Your Honor, and I think that question gets to the cognitive versus psychosocial developments. And there's really great literature on this, some of which is cited in the brief. And ultimately, the circumstances under which individuals make decisions, like getting married, like medical decisions, for example, are very different from the circumstances under which they tend to make decisions that result in unfortunate losses of life. And so while cognitively teens tend to be developed around age 16, their psychosocial characteristics like transient immaturity, impulsivity, sensation seeking, future orientation, their susceptibility to peers and peer pressure, those things are separate and deal with different parts of the brain that do not develop until much later.
But counsel, I'm sorry, I don't want to take, this is what I'm struggling with, right? Because this is an incredibly challenging issue, right? I hear your argument, I respect your argument, I understand your argument. This is what I'm trying to contend with, right, in terms of the argument that you're making. I can appreciate the distinction that exists when a young person makes a decision that's reckless or dangerous, right? Like they do something that they regret. They don't appreciate the risk. They, do something in that fashion, right? They drive fast, or they just do stuff that young people do because they're not thinking or appreciating the danger or the consequence. The distinction here is, and help me with this, here you have an individual that basically killed somebody in cold blood. They went, they killed someone sitting in a car over real estate dispute, whatever it was. I understand the facts of the case, and I understand the horrific nature of the background of the defendant. But it's the notion that, this is what I'm having really a hard time with, right? The notion that there's an innate understanding and appreciation that humans have, which is that the distinction between making a bad choice, doing something reckless, doing something dangerous, right, which all young people eventually probably do, and the notion that you are going to viciously kill someone literally in cold blood, like what happened here.
Well, Your Honor, I would start by saying that the reckless behaviors, as you mentioned, driving fast or perhaps overdoing it with alcohol, the brain is doing the very same thing and motivating the youth to engage in the dangerous behavior in those circumstances and in a situation like what we have here. And this was not a situation that involved loads of planning or really any of that cold kind of cognition that Your Honor is referencing. This was a situation where Mr. Poole's uncle went to his house, picked him up, gave him a gun, told him what to do, immediately had him transported to the scene with another adult chaperone to make sure the job got done. So I
understand.
I
get
understand,
it.
Your Honor, this is a very serious offense, but the mitigating circumstances of youth just must be considered when you're talking about someone who's 18 years old.
So and there are other instances in which it does extend beyond 17, right? Like if we look at the Holmes Youth Training or whatever, Holmes, HIDA, right, that goes up to 24, 26, for exactly these reasons, right? I mean, so, but that's a choice the legislature made. So why is that not a choice that we should have the legislature make if anybody's going to make it?
This is a constitutional question because it bears on whether the punishment is cruel or unusual. And so that is a question for this court and this court alone to decide under the Michigan Constitution. If I may, there's a quote in People v. Bullock that I think is really illustrative. That opinion reads in part, "The very purpose of a constitution is to subject the passing judgments of temporary legislative or political majorities to the deep or more profound judgment of the people reflected in the Constitution, the enforcement of which is entrusted to this court's judgment." And that's why this court should make this decision. The legislature can craft the process by which the constitutional punishments can be administered, but this court should declare the sentence unconstitutional.
Are you going to come back for a 25-year-old?
Your Honor, if the science evolves to tell us that 25-year-olds are subject to the same transient immaturity, vulnerabilities, and heightened rehabilitation, perhaps, but the science is really where we are hanging our hat and where this sentence is, this unconstitutionality of the sentence bears out. When we look at the way that the brains of these individuals have not yet been fully developed and they are not able to make decisions in the way that adults can.
Would we be, if we were to extend it or say that it applies to 21 or 25 or 23, would that be dicta in light of the fact that your client is 18?
I don't believe so. I believe this court could announce a rule and that rule would be the holding of the Poole opinion perhaps, and that would apply, Your Honor. This court
even though we didn't need to reach a different age in order to grant your client relief.
I think this court could limit its holding to the age 18 or could go beyond.
Okay, thank you.
It came up earlier in the Stovall argument, this question about based on and MCR 6.502. I'd like to touch on that briefly. The purpose of the court rules is, well, this court rule in particular, is to prevent claims that could have been brought before from being brought again, and then to allow, in specific circumstances, claims to be brought when they couldn't have been brought before. This situation we have before us does not frustrate the court rules, and it is well within them. The retroactive change in law permits this petition or this motion, as does the claim of new evidence, which of course we've covered some. There has been a sea change in the past few years. We now know that the science is extremely strong in supporting the change in law that we are seeking. And so I would just let this court know that our position is not inconsistent with the court rules whatsoever. If there are no further questions, I'll happily reserve the remainder of my time.
I have one,
Oh,
sorry,
please.
before you go, you almost made it. If we agree that your client is allowed to file a successive motion and that offenders who are 18 have a right to a Miller hearing, do we still have to determine whether or not our extension of Miller to 18 applies retroactively under Michigan law? I mean, do we have that here to be able to decide, or does that need to go back?
Well, Your Honor, that issue wasn't briefed, and I would welcome the opportunity to brief it. I will say that in two related cases, Bullock itself and then also Johner, J-A-H-N-E-R, concerning conspiracy to commit first-degree murder, and that being a parolable life sentence, the opinions of this court determined within their opinion that that decision would apply retroactively. So certainly the court could do that here. They declared the rule and said that the rule applied retroactively. As far as the Michigan jurisprudence on retroactivity, People v. Sexton controls in the state context, and the first prong of Sexton, which is the purpose of the new rule, it predominates in its importance in comparison to the second two prongs. And so I'll stick with that first one, which is the purpose of the new rule. Here, the purpose of the new rule would be to ensure that young people are not serving unconstitutional sentences. And so that purpose favors retroactive application. But again, I'd be happy to brief that if Your Honor would like.
Okay, thank you.
I will reserve. Thank you.
You may reserve.
Chief Justice, Justices, and may it please the Court, my name is David Shapiro. I represent the Roderick and Solange MacArthur Justice Center as Amicus Curiae. Thank you very much for the opportunity to present argument to the Court today. For over 50 years, this Court has recognized that Article 1, Section 16 of the Michigan Constitution sweeps more broadly than the federal Eighth Amendment. That's a result of the unique history and disjunctive text of Michigan's cruel or unusual punishment clause. In this case, the court should hold that the Michigan provision prohibits a mandatory sentence of life without parole for a young person. Such a sentence is cruel under Article 1, Section 16, because it precludes any consideration of the potential for reformation by the sentencing judge and the parole authority for the group of people who are most capable of reformation and rehabilitation. I waive the remainder of the uninterrupted time and welcome the Court's questions at any time. The distinction between a disjunctive and conjunctive prohibition is particularly significant when it comes to Michigan, because the 1850 Constitution got rid of a prohibition, a conjunctive prohibition, against cruel and unjust punishment, and replaced it with the disjunctive prohibition against cruel or unusual punishment. It was an amendment to an existing text that changed it, and so we know that it wasn't an accident. Now, the state points out in its brief that some scholars dispute that in very early American state constitutions, like Virginia, Maryland, whether cruel and unusual versus cruel or unusual makes a difference. That's a genuine dispute. I think the better view is that it does make a difference. That's the view that Justice Scalia expresses in the Harmelin decision, that cruel and unusual is different even in those early constitutions versus cruel or unusual. And a recent article by Professor William Barry, I think, makes a compelling case for that being a real difference. But it's also not really the question here, because we're not talking about 1790s Virginia or Maryland, but about Michigan in 1850. and an intentional replacement of pre-existing language. And it was done, the amendment was introduced by a delegate to the 1850 convention, Judge Benjamin Witherell, later a justice of this court, who would have known the difference between a conjunctive prohibition and a disjunctive prohibition. It was a well-established staple, that distinction in legal drafting of all sorts in the middle of the 19th century.
Was that difference understood to mean anything differently at that time? In other words, were there distinct concepts that he was invoking when he chose that formulation?
Unfortunately, the history surrounding that particular provision is pretty sparse. The debates indicate that then Judge Witherell introduced the provision, striking out the old language and replacing it with the new language.
The opposing counsel points out in his brief that the alternate formulations were fairly commonplace throughout the country's history and the history of the state constitutions. And he argues that the different formulations between the conjunctive and the disjunctive did not signify a different meaning for the phrase. Do you have any historical evidence to the contrary?
Well, many states, courts that have disjunctive prohibitions, as this court does, interpret the provision to mean something very different, to be a broader prohibition.
Is that a modern phenomenon, or is that a historical development?
To the best of my knowledge, it's a phenomenon within the past 50 years. Of course, many states have enacted constitutions in more recent history, as this state reenacted the cruel or unusual punishment language in 1963. And then in 1972, this court, just 9 years later, itself said that the prohibition of punishment that is unusual but not necessarily cruel carries an implication that unusually excessive imprisonment is included in that prohibition. That gets reaffirmed 20 years later by this court in the Bullock case, where this court says that the phrase in the form A or B necessarily encompasses a broader sweep than the phrase A and B. But I do think the key question, or one of the key points, when we're thinking about whether there's history supporting a material difference, is why would the delegation decide to amend the prohibition when they had a pre-existing disjunctive one, only to replace it with something, or a pre-existing conjunctive one, only to replace it with something that meant the same thing? That's a pretty salient fact that suggests that there is likely a material difference in the meaning that was intended by the 1850 delegation. Now, the text of this state's constitution doesn't say exactly what it is that makes a punishment cruel, but the 1850 debates provide important guidance on that question. Punishment, many delegates indicate, is illegitimate if it totally denies the possibility for reformation. And that is exactly what a mandatory life without parole sentence for a young person does, and does in the extreme by taking the class most susceptible, most capable of reformation, and saying that neither the sentencing judge nor the parole authority can consider a sentence other than life without any possibility of parole.
It does that for all offenders, of course, right, by design?
I'm sorry?
It does that for all offenders, right, by design. Doesn't give them a chance to show reformation, even if you're over the age of this defendant or the age of 25.
The statutory structure, Your Honor is referring to?
Yeah, your point proves a little too much. If we look to that language in the 1850 debates as a sentence being cruel if it doesn't provide an opportunity for reformation, this one by design doesn't allow that opportunity for anyone.
That's true, and I think that there, is some support in the convention history for a broader prohibition against mandatory life without parole sentences. I'm sorry. Yes.
Well, I was just going to say, at that time, I think, well, I guess my head's getting jumbled now, but Michigan had the death penalty, or no, in 1850? Not then. If it had, for states that had the death penalty, that wasn't considered cruel. True?
I don't think that's the relevant, that's true, but I'm not sure that it's the relevant question when we're talking about the Michigan delegation. And the history there, as I understand it, is that in 1847, Michigan abolishes the death penalty, replaces it with life imprisonment. The information that I've seen suggests that that really didn't operate like a modern life without parole sentence, in the sense of life is life, but that the pardon and commutation power was exercised so liberally that essentially it resembled a modern life with parole sentence. In other words, people were not expecting, as far as I understand it, to go to prison, even on a life sentence, with the expectation that they would necessarily grow old and die while incarcerated. I see that my time is up, so I'll conclude. Thank you very much, Your Honors.
Thank you, counsel.
Good afternoon, Your Honors. Tim Boffman, Assistant Prosecuting Attorney, representing Kim Worthy, the Prosecuting Attorney for the County of Wayne. To paraphrase Justice Holmes in his Abrams dissent, if you want a certain result with all your heart, you naturally express your wishes in constitutional law and thereby sweep away all opposition. The defendant and his amici wish a certain result. They want to end mandatory life in prison without parole for the taking of another human life with premeditation for those who are 18 to 25 years of age. And they know that if at least 4 members of this court accept that proposition as a matter of constitutional law, opposition is thereby swept away. They thus present to this court extra record scientific material regarding the maturing process of the human brain, asking the court to make a different policy decision than has the legislature and determine that to sentence those who are 18 to 24 for first-degree murder in the same manner as those who are older are sentenced is cruel and unusual punishment. The court is in effect asked to sit as a legislative committee, effectively a committee of the whole, and determine that what we submit is a question of policy, even assuming that 18 to 25-year-old brains are still developing. Are they sufficiently mature that they should suffer the state's highest penalty for committing the gravest crime? And lost in kind of all this is the death of Henry Covington, his life taken on a cold early morning by the defendant with premeditation and for pay. The court should decline to be treated as a legislative committee. The determination of a proper punishment for a criminal offense is ordinarily one for the legislature. As the United States Supreme Court noted in the Gregg case 4.5 decades ago, in a democratic society, legislatures, not courts, are constituted to respond to the will and consequently the moral values of the people. So if one wishes to make the case that 18 to 25-year-olds should be treated differently in terms of sentencing for a first-degree murder, the case can be made to the legislature, and rather than this court sweeping away all opposition, those who wish to be heard on the other side of that question may present their views to the legislature, and the sentence, which has existed, I think, for almost if not the entire history of the state, life without parole, mandatory life without parole for a premeditated murder, applying to the class of individuals brought before the court today, 18 to 25-year-olds, would be a matter for the legislature.
If we rule as defense counsel is requesting, we would do more than sit as a legislature. If we constitutionalize these sentences, would we not? They would not be subject to being overturned by any majority of the legislature in the future.
That's correct. By constitutionalizing it, all opposition would be swept aside. The political branches could not act. And I would...
I just make the point that we'd be taking it out of the popular process
Yes.
altogether.
We'd be taking it out altogether.
Save an amendment to the Constitution.
And I would point out as to Justice Kavanaugh's question earlier, would it be dicta if the court went beyond 18-year-olds? I might have thought so, but Miller, the defendants in Miller were 14 years old, and the United States Supreme Court drew the line at 18. So nobody seemed to think there was a problem with the court deciding that the line was 18 when 14-year-olds were before the court. So what the defendants are really arguing here with their scientific material is that 18 at least through 24-year-olds, should be treated differently, and certainly a 19-year-old not differently than an 18-year-old, a 20-year-old not different than a 19-year-old. So they really do want the line at least 25, which would really be a dramatic thing to do. It is true that in terms of retroactivity, this court does not have to apply the rules that the United States Supreme Court applies with federal constitutional decisions to its own constitutional decisions under the state constitution. But it strikes me, though I might be arguing on the other side of that if it were before the court, that the court might be hard-pressed to tell, for example, Mr. Manning, who was before this court a year or so ago, you lose, and Poole wins in terms of getting a resentencing. So you might determine that it should be retroactive. You might say that the line has to be drawn at 25, and then you're talking at close to probably 2,000 new Miller-type hearings based on this state constitutional decision. And what was the penalty, by the way, in 1850 when the Michigan Constitution, that Constitution was ratified? The penalty was life in prison, in solitary confinement at hard labor, and there was no parole. There were commutations or pardons, but I don't think you can view the governor's exercise of the commutation or pardon power in this area that exists today. And in fact, Mr. Poole could try to get the governor to exercise his pardon power. So I don't think there's anything in the history, structure, or text of the Michigan Constitution that should lead it to do differently than has the United States Supreme Court in dealing in this area. In case after case after case, it has drawn the line at 18. And it has done so recognizing that, of course, 18 is not a switch where things change dramatically in terms of an individual's development. As the court said in the Roper case, it understood that some people were far more mature before 18 than some adults ever get to be. It's not a switch, but it said because 18 is the line in which society, in many circumstances, draws the line between childhood and adulthood, it believed that 18 was the appropriate line to draw.
What about where
execution.
where society has drawn the line differently? Like I mentioned in Haida, we forgive or recognize, given the factors of youth and the mitigating circumstances of that that extend beyond 18.
For certain offenses only, though.
Sure.
The legislature has limited its exercise of its power in that regard to treat individuals of a certain age differently than individuals who are older, but it has not chosen so to do with a premeditated murder. And the question is it entitled to make that choice, or is it unconstitutional for it to do so? And I would submit it is not unconstitutional. It's the exercise of its proper authority in making that decision. And if it's to exercise its authority differently with regard to first-degree murder for a class of defendants, then it certainly may do so if the case is made to it and it accepts that view. But opponents are allowed to be heard, and the legislature may determine that it's not going to make such a decision.
Counsel, I have a question. What is it that is the concern of the people in terms of if the court were to rule in a different manner? What is the practical implication? What is the concern that the people have in regards to this resentencing component? I mean, people aren't going to go free. What changes? What is it that you're concerned about?
Well, principal concern, as I've said, is that the legislature should get to make this decision. If the court were to rule otherwise, then I'm not sure where you would draw the line if you went. I don't see how you could stop it at 18, and if you went up to through 24, then there are huge practical concerns with regard to what, as I understand it, are somewhere close to 2,000 individuals who've been convicted of first-degree murder who are under the age of 25.
What would that be, though? It's a new hearing, I understand what would happen, but what is it that your office is concerned about? That it's just, you're gonna have to resentence, you're gonna have to,
Yeah, we're
what's the
concerned
main
about
concern?
holding hearings in all of these cases when, in our opinion, the sentence, as I've said at the outset, as our opinion, the sentence that was imposed is perfectly appropriate. The legislature has the authority to impose it, and it shouldn't be upset. Let me try to put it this way. If a trial judge sentences outside the guidelines, then the rule of decision for the trial judge in making that decision is the sentence must be reasonable, applying the principle of proportionality. That's what this court has said in Lockridge and Steenhouse. And the appellate standard of review for that is an abuse of discretion. Is that decision, sentencing decision, outside the range of principled outcomes? So the way they put it in the federal system is could any reasonable jurist reach that conclusion? And if not, it's an abuse of discretion. This court would have to tell the legislature that in determining that this class of individuals, even if their brain is still maturing, that if they've determined, as they have, that this class of individuals suffers the most severe penalty for committing the gravest crime, that decision is not only outside the realm of reasonable legislative decision-making, because this court doesn't have a review power of abuse of discretion over the legislature. It would have to say it is so far outside the realm of what a reasonable legislature might do as to be grossly create, if we follow proportionality, a grossly disproportionate sentence, one that is just beyond the pale for the legislature to act that way. And again, this court does not act as a super legislature. It doesn't act.
Are we acting as a legislator, or are we saying, this would not certainly be the first time that we'd say legislature, something that you enacted, is unconstitutional. Our role is, in fact, to interpret the Constitution, right?
Correct. Absolutely. And in doing so, in this area where the legislature has determined what is an appropriate sentence for all adults, you would be saying that determination, which is presumed to be constitutional unless it is clearly shown to the contrary, that decision is not just wrong, it's not just disproportionate, it amounts to cruel and unusual punishment based on what?
Do you disagree with the science,
I
scientific literature about brain development?
I don't agree with it, and I don't disagree with it. I don't believe it's appropriate before a court. I believe it's appropriate before a legislature, because I think it's completely a policy decision, even if true, that brains are developing from 18 through 25. And again, even the Roper decision says we understand that there's not a magic line at 18. Even if they're developing, the legislature can still say, when that class of people commits this crime, they suffer the penalty of life without parole.
Unless that violates their constitutional rights.
Unless it violates the Constitution, but to say that, you'd have to say more than, gee, we think that's a bad idea. You'd have to say it's cruel and unusual punishment. You've gone off the track so far that you violated the Constitution. You're not entitled to make this decision.
But can't we use science to determine what's cruel or unusual?
Absolutely. I mean, but based on what? The fact that we have a cruel and unusual punishment clause doesn't mean, well, now the courts can do whatever they want. They still have to determine, has the legislature acted in a manner that is unconstitutional? And there's nothing in the text or history of the Michigan Constitution that we submit that would provide that would mean that this sentence, which has existed for probably 175 years or more, that everybody 18 to 25 who's ever been sentenced in Michigan for first-degree murder was sentenced unconstitutionally. I don't think there's anything that supports that. We would ask the court to hold that the Michigan Constitution does not disable the legislature from applying its harshest penalty to the 18 and 25-year-olds who commit first-degree murder. Is there no further questions? Thank you very much.
Thank you, counsel.
Part of this court's role is to look at the evolving standards of decency and determine whether, based on those evolving standards, any given punishment is unconstitutional. The Bullock test sets up a framework for looking at evolving standards of decency and other things. We passed the Bullock test, as outlined in the brief. I don't know that that's disputed. And so by nature of making it through the 4 prongs of the Bullock test, this penalty is unconstitutional. Miller was a constitutional decision that resulted in a legislative response here and elsewhere, and that's what should occur here. This court should declare the penalty unconstitutional, and the legislature should develop a framework. Whether it mirrors 76925 and 25A or not, that would be up to the legislature. That's the legislature's role. Constitutional questions always implicate actions by the legislature, and so if this court were to strike down mandatory life without parole for this age group, it wouldn't be legislating from the bench, it would be enforcing the Constitution. I want to point out that under the relief that we request, life without parole would still be an option. It's just that mandatory life without parole would be unconstitutional. And that youth must be considered at a sentencing hearing when the judge is deciding whether to impose a life without parole sentence or a term of years. The prosecutor mentioned that this could result in many more.
Could it be argued that you're trying to argue that you're simply trying to give discretion to lower courts to make these determinations?
Yes, Your Honor, and to allow the parole board, when it comes time, to make a decision about whether that individual has been rehabilitated. Yes, because it's too early at the time when someone is 18 or 25 or whatever age in between, it's too early to make a decision that will be unchangeable for the rest of their life. That's exactly what I'm arguing. The prosecutor mentioned that there may be hundreds of hearings, and I would first say that this court's concern is constitutionality, and the efficiency concern is not part of the Bullock test. It's not part of a determination about whether the sentence is unconstitutional. The Miller court did not burden itself with questions or concerns about hearings or efficiency. It rather left that to the respective legislatures in the states. I think if there are no further questions,
Is there a chance this could be a sliding scale, and that like the next group will come along and say, well, now it's, I know this, this is, maybe a little out of range, but the next group would come along and say, well, now it's 25 to 30. Is that a possibility? Is that something I have to be concerned about? Or is this definite? I'm just trying to, you know what I mean? I'm trying to conclude here like the state's position, which is, hey, this is what they said. The legislature set this policy. The legislature set this. This is what they said was the sentence. This is what they said it was going to be. And now the court's coming along and saying, hey, that's unconstitutional, for all these various reasons, like the brain science, and that the science is basically going to dictate that the court's able to then upend what the legislature has ultimately determined as the determining sentence.
That, I believe, Your Honor, is the nature of a prohibition on cruel or unusual punishment. It does evolve over time. And so while at one time we executed juveniles in this country, that's no longer permitted. At one time we incarcerated juveniles in this country for life without parole sentences for non-homicide offenses. That's no longer permitted. At one time in the not too recent past, we incarcerated those under 18 for life without parole for homicide offenses, and now we don't do that anymore as a mandatory scheme. And so we're asking that this court take the next step to constitutionalize a punishment that is supported by the science, Your Honor, and that would give the lower courts discretion to make those determinations on an individual basis.
How fast do our standards of decency evolve?
I don't know that there's a timeline that would tell us when the next change might come about. But here, where you have strong science in support of this position, I think we can say that our evolving standards have
So did
changed.
SCOTUS and Miller, they just blew it? They were completely wrong about the science? They didn't follow the science, as we hear, that phrase we hear so often?
The science,
They just screwed up? Or has the science changed, or have our standards of decency changed?
there are a lot of factors to look at when we apply the Bullock test. The science has evolved since Miller, which was a decade ago. And that isn't surprising considering how quickly science and technology do evolve these days. We also look at penalties in other states, and some other states have changed penalties.
Aren't
since that time.
aren't these all arguments for why this goes to the legislature? The science changes rapidly, can be considered by the legislature and debated like it does in so many other ways? Or are you gonna be back in our court next week and next month, and we're gonna be refashioning reviewing all the work that they do and say, well, how do we feel today about the science, and how we feel today about this penalty or that, and whether we think it's a good one or not?
I go back to my answer that this is a constitutional question, and I understand that the legislature does have a role to play. They set the penalties, and then this court reviews them. Using the existing law, the Bullock test, you look at various factors and ultimately determine whether this penalty meets those factors or whether it's an unconstitutional penalty. And here, it is an unconstitutional penalty under the test that this court adopted.
All right, thank you, counsel.
Certainly. Thank you very much.
Thank you both. The case will be submitted.